So let's get right into it. Picture this. At the very same moment, one of the biggest prosecutions in American history is suddenly dropped. A federal agency is quietly given a brand new, sweeping power. Now, these two events seem totally separate, right? But they both hinge on one single, critical idea: the power of the executive branch. So how on earth do they connect? Well, that's what we're going to figure out.
The stage was absolutely set for a political explosion. After President Trump won in 2024, the former special counsel Jack Smith was called to testify before Congress. For critics like Judiciary Chairman Jim Jordan, this was their moment, a chance to prove, as they saw it, that the cases against Trump were never about justice, but were just a political weapon.
But here's the twist. Jack Smith, in his testimony behind closed doors, was completely unwavering. He flat out told lawmakers his team had proof beyond a reasonable doubt, that Trump was guilty. So on one side, you have a prosecutor who was 100% confident in his case, and on the other, a political world screaming witch hunt. So, what happened?
Well, it was dismissed, just like that. After Donald Trump's election victory, the Department of Justice itself moved to have the federal indictments against him thrown out. Now, this wasn't a jury saying not guilty. This was a decision that came from deep inside the executive branch itself.
Okay, so that raises a huge question, right? How can the very same government that was so sure of its evidence suddenly ask a judge to just drop the whole thing? The answer has nothing to do with the evidence in the case. It's all about a long-standing and pretty controversial rule about the office of the president.
The whole thing comes down to something called an Office of Legal Counsel opinion, or an OLC opinion. You can think of the OLC as the Justice Department's own internal Supreme Court. When it issues a ruling on a big constitutional question, that ruling is law for every single federal prosecutor. It's not a suggestion, it's a direct order. It ensures the entire government is on the same page.
And hey, this isn't some new idea they just cooked up. The OLC first decided way back in 1973, during Watergate, that a sitting president just can't be prosecuted. They looked at it again in 2000, after the Clinton impeachment, and they doubled down, calling it a categorical rule. Fast forward to 2024, and they applied this 50-year-old precedent to a situation no one had ever seen before: a defendant who had just been elected president.
So why? What's the logic here? Well, it all boils down to what they call the three burdens. First, the obvious one, the threat of prison. Second, the public stigma, the idea that a president under indictment can't effectively lead the country on the world stage. And third, just the sheer mental and physical drain of preparing a defense, which they argue would make it impossible to actually do the job of being president.
But, and this is a really important legal detail, the case was dismissed without prejudice. That is not a get-out-of-jail-free card. Think of it more like hitting a giant pause button. It means the immunity is temporary. It only lasts as long as he's in office. In theory, the prosecution could be started right back up the day his term ends.
Okay, now we're going to pivot. Because at the exact same time the Justice Department was reaffirming this major limit on its own power, another federal agency, Immigration and Customs Enforcement, or ICE, was doing the exact opposite. It was dramatically expanding its power.
Now, to really get this, you have to understand that there are two totally different kinds of warrants. First, you have the judicial warrant. That's the one you see on TV, signed by a neutral judge, based on probable cause of a crime. Then there's the ICE administrative warrant. This one's different. It's issued internally by another ICE officer for civil violations. And for a very long time, it did not give agents the power to force their way into your home.
And that wasn't just some vague understanding. It was the official government position for decades. I mean, look at this. All the way back in 2007, the head of Homeland Security himself said these administrative warrants are not the same. They don't give you the authority to enter a home like a judicial warrant does. Plain and simple.
But then, it all changed. Whistleblowers brought to light a secret internal memo from May of 2025. And this memo didn't just tweak the policy, it completely blew it up. It basically flipped the entire rulebook on its head.
And here's the key line from that memo. It says the agency's own lawyers had recently determined that the Constitution actually does allow them to use these internal administrative warrants to force their way into people's homes. I mean, this was a complete 180-degree reversal of decades of legal interpretation and policy. A massive shift.
And the memo was brutally clear about what this meant for agents in the field. It gave them explicit authorization to use a necessary and reasonable amount of force to get inside someone's home, all based on that piece of paper that was signed not by a judge, but by another person in their own agency.
This new policy didn't just sit in a file cabinet, it hit the streets hard.
Just months after the memo was signed, ICE launched something called Operation Metro Surge in Minnesota, and things escalated tragically fast, leading to the shooting death of a resident, Renee Good, and prompting the state of Minnesota to sue the federal government.
And that lawsuit, wow, it painted a terrifying picture of life on the ground. The state alleged widespread racial profiling. It described a community gripped by so much fear that schools were going into lockdown and local businesses saw their revenues just crater, some by as much as 80%, because people were too scared to leave their homes.
And you can see the immediate strain on local resources. The city of Minneapolis calculated that it burned through more than $2 million on police overtime in just the first 4 days of this federal operation, just trying to manage the chaos.
So let's pull back and put these two stories side by side. On the one hand, you've got the presidency being treated like a temporary shield from the law. And on the other, you have a federal agency forging a new kind of sword for itself. Both of these come from two clashing ideas about what executive power really means.
And that right there, that's the stunning paradox at the heart of this whole thing. You have one part of the executive branch saying the Constitution acts as a shield, that it limits their power to prosecute their own leader. And at the exact same time, another part of that same executive branch is arguing the Constitution is a sword, that it expands their power to forcibly enter our homes.
So what this all really shows us is that the rules for executive power aren't carved in stone. Not at all. They are constantly being argued over, reinterpreted, and redefined right before our eyes. And that leaves us with one last massive question. When the fundamental rules of power are being rewritten, who gets to have the final